Hello, everybody. We are here for part 4 of our Firearms for Private Detectives and Protective Agents course. I want to remind you that there's a reading packet that's in a PDF format, and I'm going to be referencing some of that through this section. There is some statutory information. There's an article written by the National Association of Defense Lawyers about defending a self-defense case. There's an article on pre-attack indicators and nonverbal cues. There's a section on safety rules and a little bit more in-depth information about that. Goes over our first lecture, ammunition information, as well as some of the many things that we'll be discussing today. So let's get started. So the first thing, I guess I need to share my screen here, don't I? First thing I'd like you to do is review Minnesota Statute 609.06. And that statute discusses when anybody in the state can use force. And force is really basically the exertion of, at least in our context, the exertion of our will against another. So it would include certainly shooting somebody, but it would also include using OC spray. It would include going hands-on with somebody. It would include restricting somebody's movement, things like that. So it's an important statute for you to read. It's about a page long, and it's we're going to go over a lot of the details, but I want to make sure that you actually read it and take a look at it. So this is, I think, the best representation for our purposes of the use of force continuum. Sometimes you'll see it in a little step diagram, but this one I like because it shows the escalation and de-escalation. So at the very bottom of the use of force continuum is presence. And when I was studying law enforcement, for those of you that are current or retired police officers, you know this well, officer presence, having a confident, calm, authoritative presence, the sight of your uniform sends a message. Just being there, showing up is a big deal. For plainclothes people and private security, we don't have necessarily that inherent authority that law enforcement has, that society looks at and says, you know, this is somebody I have to listen to. And so sometimes people don't think that's important for private detectives and protective agents, but it's actually not true. Having the type of presence that you are in control of the situation, you're calm under pressure, you give directions as if you have the authority. And I'm not talking about directions to do things that are inappropriate. I'm talking about stop or some other command that's reasonable given the circumstances. That actually resolves a lot of things. For a number of years in our firm, back in the early 2000s, we did a lot of repossessions. We haven't done them in many years, and we probably won't go back to it, but people always asked, did people fight you or scream at you or threaten you? And the answer was almost never. And for us, it was because of how we approached the situation, our body language, our stance, our respect for the people involved, and our direct instruction to them. And when you treat people with dignity and respect, and you look and act and are professional, a lot of things de-escalate very quickly. The next level of force is verbal force. That's when you issue those commands, you tell them what you want them to do, and you don't make it ambiguous. Again, doing it professionally. One of the things we're going to talk about is, in today's modern age, as all of you know, the chance of you being filmed in a use of force encounter is very high. And not only do you want to use verbal force effectively to resolve the situation safely, but you also want to make sure that there's not a video out there, if it does escalate, of you swearing and screaming and looking like you're out of control. That will not help you, and it won't help the situation, even more importantly. So make sure that when we're speaking with people, whether it's in an emergency or it's not, we're avoiding profanity. We're speaking clearly and calmly and confidently, even in an emergency. And it doesn't look like we're freaking out. It doesn't look like we're in code black. Okay, we want to be in code red. Remember those color codes in situational awareness. Red was we're taking action. Black is we're panicked and freaking out, and we don't want that. That will not make you look like a professional in front of a jury. It certainly won't help the people around you in the situation to get it resolved safely. And so that's important to recognize. The next stage is empty hand force. That is essentially hands-on. That's where you're not using any type of a weapon. You are, you might be in a tussle, you might be in a fight, you might use basic punches and kicks, blocks, elbows, knees, things like that. The next stage is weapons force. And I think traditionally this stage has kind of been split in two. Certainly the, taser, for those of you that might carry tasers or batons, that would apply here. Sometimes I'll see OC spray actually between verbal and empty hand force. And sometimes I'll see it weapon force. And so that's kind of, it's not universally agreed upon, but some departments put it in different spots. For me, I would say OC spray is before empty hand force. Because of my stature, I'm not in a position to get in a hands-on fight with a 21-year-old at my stature and my age. And so OC spray, we know, is almost never going to have permanent or long-term effects. They're going to recover in about 30 minutes. We don't have to worry about somebody having a traumatic brain injury or falling down and cracking their head like you might with a baton or even a taser. So you'll have to talk to your department. But for our employees, I would much rather them use OC spray a little lower before they get hands-on if they can. And if you haven't been trained on OC, you should be, including, I know now they use, some departments don't make somebody actually get sprayed, they used inert spray. I think it's really important that anybody who carries OC spray be sprayed with OC spray so they understand what their opponent is going to go through and have some empathy. And also understand what will happen, because when you spray your opponent, your assailant, you're probably going to get some in your eyes too. And we can't go into condition black. Let's keep thinking about those conditions. Condition black's a bad thing. And if you're blinded and you got eyes clenched together that you can't open, it's easy to get panicked. Keep in mind, you have a firearm with you and you're responsible for that firearm at 100%, 100% of the time and 100% of circumstances, whether you have OC in your face or not. So you got to make sure you use that wisely. So obviously the highest level of force anybody can use is deadly force. Deadly force is the highest. And deadly force isn't just a firearm, but a deadly force could be stabbing someone. It could be using a baton or other blunt instrument to hit them in the head. It could be kicking them in the head. So deadly force shouldn't be totally just construed to a shooting. There's other types of deadly force that the law will look at as being commensurate with a firearm use. So that's the use of force continuum. As you go up, it's escalating, and obviously as you go down, it's de-escalating. One of the questions that police who enter private security or who enter executive protection, who become private detectives, sometimes forget in law enforcement, remember that police are given extra power by the people. The community elect a city council and a mayor, and that body, either the mayor or the council, depending on the form of government in that state, appoints a police chief who then appoints police officers. They are agents of the government. And we have agreed to let them do things that we cannot. And we being and including all citizens and including private detectives and protective agents. So in the police world, you're typically allowed to go one step over the resistance being displayed to you. So if somebody is using their presence to intimidate you, you're allowed to, go to verbal force. If somebody's verbally resisting you, you're allowed to put your hands on them and escalate that. But for private detectives and protective agents, you're not. So the general rule with private citizens and protective agents and private detectives is you can match the other person's force, but you generally can't go beyond it. And so remember that if somebody is using a weapon that is unlikely to cause you death or great bodily harm, and we'll talk about what that means in a little bit, it doesn't mean you get to shoot them, right? So like, for instance, there's a difference between a baseball bat being swung at your head and somebody, throwing a stapler at you or throwing some other object at you that's might hurt you, it might injure you, but it's probably not going to kill you. And so make sure that you think about this and you kind of pre-plan in your head different scenarios. If this happened, here's what I would do. If that happened, here's what I would do, because you don't want to use, let's say OC spray against somebody who's just providing, verbal non-compliance. That would be inappropriate for private detectives, protective agents, and other private citizens. So just keep this in mind, come back to this, think about it, and make sure that you're conscious of that difference, especially for you police officers and retired officers. Minnesota law has a separate statute for basically the use of deadly force. They call it justifiable taking of life. And it's one paragraph, actually it's one sentence, I'll read it now. And then we'll talk about some of the case law that's developed around that concept. So the law says, the statute 609.065 says, the intentional taking of the life of another is not authorized except when necessary in resisting or preventing an offense which the actor reasonably believes exposes the actor or another to great bodily harm or death, or preventing the commission of a felony in the actor's place of abode. So let's parse that out. First of all, we're talking about the intentional taking of life. Now, that doesn't mean that you can shoot somebody on purpose and say, well, I just wanted to stop them, I didn't want to kill them. No, that's not what we're talking about here. When you take an action that's likely, you knowingly take an action that's likely to cause death or great bodily harm, it's going to apply. It's going to apply here. That's the intentional taking of life. The next section that I think we have to look at is except when necessary. So remember, we don't get to escalate like police do. We can't go beyond what our assailant is doing. So it has to be necessary. We're going to talk about the term preclusion quite a bit today. So except when necessary in resisting or preventing an offense which the actor reasonably believes exposes the actor or another to great bodily harm or death. So the word reasonable is really important in the legal context. And how that's defined is the reasonable person standard. It used to be called the reasonable man standard. Now it's called the reasonable person standard. And it's widely adopted throughout the country. So what that basically is we're going to pick 12 people who are average everyday citizens, and with the benefit of hindsight, they're going to have to decide if a reasonable person, if they would have reacted the way you did. And so it's not what you think is reasonable, it's what the average citizen thinks is reasonable. And that's a really important distinction. And then the final clause is or preventing the commission of a felony in the actor's place of abode. And that one's had some case law we're not going to get into today. That's the Castle Doctrine. And Minnesota has restricted that a little bit. So it doesn't mean anybody who comes into your house to burglarize it, you can kill. In fact, there's a case in northern Minnesota where a man was in that situation. Somebody was breaking into his home and he shot and killed both of them. They were young people, and he's in prison for the rest of his life. Now, there were some other factors that played into that, but I just want to make you aware that that one clause has had some litigation, and so you should contact an attorney or somebody else to help you understand that if you're concerned about crimes happening in your home. One other note I'll make is abode does not mean your garage, your shed, your property. It certainly and only means the actual place that you live and sleep. So it's not a broad term. It's actually a fairly narrow term. So this is in your packet. Read it and make sure that you understand what it's saying. Parse out all that language and take your time as you read it. So let's talk shortly about the alternatives to deadly force. The first and most important alternative is avoidance. We talked a lot about that in situational awareness. If you end up in a situation where you have to use deadly force, your whole life is going to change. Your employer may have an insurance policy that pays civil claims like a lawsuit if somebody sues you, but none of your employers are going to pay to hire a criminal defense attorney to represent you. You're going to have to do that. And you're going to have to pay those fees. And as you might imagine, defending a homicide case is very expensive. I've heard reasonable estimates in Minnesota to be around $1 million. And that will be a problem because most of us don't have $1 million. And that means we're going to have a less qualified attorney or no attorney. Or if we can afford a good attorney, we won't be able to afford the expert witnesses that would help explain things to our benefit. And so why put yourself in that? Why put yourself in a predicament that you wouldn't otherwise need to be in? Now, there is a little bit of a caveat to that for us. For the private citizen, avoidance is absolute. I mean, if you and your children and your spouse or whoever you're responsible for can get the heck out of there, 100% of the time, that's a good thing. For private detectives, less so, but for protective agents more so, there might be situations where the people you are responsible for are the general public. So let's take an example of a security officer, an armed security officer who works at, let's say, a bank. And the bank is being robbed, and the people who are robbing it have firearms and are threatening to kill people. Maybe they've already fired shots. I think society would agree that they expect you to engage that suspect. They don't expect you, even if you have a chance, to run away. So I think there are some nuances to the avoidance strategy for particular times. And that's pretty limited to on-duty, officially licensed and armed protective agents. If you're a bodyguard, if you're an executive protection specialist and your principal comes under attack, nobody expects you to leave your principal alone because you could get away. And so I think there is a little bit of a nuance there. Now, you certainly would be expected to avoid dangerous situations if you could have foreseen them with your protectee, right? I mean, that makes sense. The second alternative is to retreat. If you and those you are responsible for, I'll say that again, can safely and reasonably get out of there, do it. Do it. There's no value in staying and having to shoot somebody that you otherwise wouldn't have had to shoot. The third is verbal de-escalation. We're going to talk about fighting words in a little bit, but you have to be able to talk to people, and you have to be able to avoid condition black, because if you have a chance to talk your way out of that problem or to convince the other person to let you leave safely, you should do so. When I was studying police work, we spent quite a bit of time on verbal judo, which is a system by Dr. George Thompson. There's other verbal de-escalation systems out there. You should study them, and maybe get some of the books that are related to it or some of the online lectures, and really look at that, because that'll be scrutinized. If you had the option to talk somebody down and you didn't, really, you're starting to cross the line from a self-defense shooting to a murder shooting. So be careful about that. And then think of your less lethals, your non-lethals like OC spray, how you could employ them early. We had a situation one time, I wasn't there, but where we were trying to serve a subpoena or a child support order or something to somebody, and the person grabbed a baseball bat and chased our detective. If the man with the baseball bat got close to our investigator, close enough to make contact with him, theoretically, the investigator would have been justified in shooting him if he really believed in that the person was going to strike him in the head with a bat. But, 10 feet earlier, that investigator could have deployed OC spray and avoided the use of that firearm. And I think that's the way you have to look at this, is where in that interaction can I use less lethal tools? So what are the elements in Minnesota of self-defense? This came out of a Supreme Court case, I believe in the late 90s or early 2000s. And the court said, well, there are 4 things that somebody must be able to show before they can claim that they were acting in self-defense. These are the things that the jury would have to believe are true before they would acquit you of a crime of murder or manslaughter. There are 4 elements. The first is the absence of aggression or provocation on the part of the person making the self-defense claim. You cannot escalate the situation, shoot somebody when they raise up and then claim self-defense. It's unreasonable to believe that you could do that. And obviously it's bad public policy, because everybody would just provoke fights and then use their firearm and then claim self-defense. So this is an important distinction to make. You cannot be part of the problem. You have to be able to articulate that you use the right tools, that you use the right strategies. And then if there's a video of you calling somebody, a mother effer or an SOB, or saying something bad about the person's family, you're going to have a hard time making that claim. The actual and honest belief that imminent death or great bodily harm would result. So imminent means right now. Doesn't mean in 5 minutes from now or in 2 minutes from now. It means right now. You need to have a reasonable belief. Okay? Reasonableness, reasonable standard. What would a reasonable citizen, average, everyday Joe American think? And then you have to have the absence of a reasonable means of retreat, or otherwise ability to avoid the confrontation. So let's look at that. The absence of aggression doesn't mean that you can't tell people they don't want to hear. If you're a security officer and it's private property, let's say, and you say, hey sir, unfortunately you've been trespassed. I need you to leave. That's not what we're talking about. But what it does mean is fighting words like we talked about a few minutes ago. Language that is patently inappropriate. When you are the one who's out of control with your mouth, when you are the one that are challenging somebody to a fight, that's going to get you in a lot of trouble. Okay. So whether you're a professional investigator or protective agent, you're going to be held to a higher standard. So the average juror isn't going to expect a licensed professional to be engaged in the same conduct as their assailant. They want to see somebody who's cool, calm, collected, maybe upset a little bit, but is in control of themselves. And I think that's really important. So speak professionally, use verbal judo or some other appropriate system, avoid profanity, do not insult or challenge. That is going to cause you a whole bunch of problems. And remember, everything now is on audio or video recording pretty much anywhere. So the actual honest belief standard. So you got to believe at that moment that you're in danger. The knowledge you learn after the fact doesn't count. You can see there's a court case here citing. So for instance, let's say that you have an incident with somebody and you have to use deadly force. And you find out the next day that the person was a convicted cop killer. Doesn't matter. You can't use that to tell the jury that this guy was a cop killer. And so I was really in fear for my life. It doesn't matter. You didn't know it at the time you used your firearm. So it's the things you know up to that moment, not the things you learn after the fact. The key aspect of this is imminence. So somebody saying, I'm going to go in my house and get a gun and shoot you is not an imminent deadly threat. If they have the gun and say, I'm going to shoot you, then it likely is. So the definition of death is pretty obvious. It's likely to cause death or great bodily harm. So in most states, the general definition is crippling injury, not simply a physical harm or even substantial physical harm. Minnesota law has a definition for great bodily harm, which we'll look at. They also have one for substantial bodily harm. And then the third one is just simply bodily harm. And so we'll talk about the definition of great bodily harm in a little bit, but it's not just simply a broken nose, a fat lip, a black eye, a broken finger. It's more than that. And that standard brings it up for your use. So here's the definition of great bodily harm in Minnesota law. So it's bodily injury which creates a high probability of death or which causes serious permanent disfigurement. So not just permanent disfigurement, but serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. Now notice in the prior language, I told you that there is great bodily harm in Minnesota, substantial bodily harm, and bodily harm. Serious bodily harm is not the same as substantial bodily harm. So a high probability of death. A bullet hole certainly counts. A stab wound certainly counts. A baseball bat to the head probably counts. A serious permanent disfigurement, losing an eye, for example, would be one example I could think of right now. Losing the ability to think because you have a traumatic brain injury would be an example, because you took a baseball bat or 2x4 to the face and had a major concussion. These are the types of things we're talking about here. So let's talk about reasonable fear and bear fear. And I don't mean bear like a big growly black bear. I mean a bear like naked fear, okay, bear fear. So remember that if you were without fear, you'd be without legal justification for using deadly force all the time. So one of the things you want to avoid if you're ever in an encounter is don't be macho. We don't want to say, well, were you afraid of him? Well, not really, because you're trying to be a tough guy. Be honest in your interrogation, but make sure that you realize not to try to beef yourself up here. That's not the time. Bear fear is defined as why I was fearful in the situation, but reasonable fear is defined as why any reasonably prudent person would be fearful. So remember that word reasonable isn't reasonable to you. It's what's reasonable to the average prudent American citizen who's sitting in that jury box. And what is reasonable in Minneapolis, Minnesota, is different than what's reasonable in Duluth, Minnesota, and it's definitely different than what's reasonable in Bemidji, Minnesota. You think about your jury pool. Are you going to have a bunch of conservative jurors who are, tough on crime? Or are you going to have a bunch of jurors who are, of the liberal persuasion? These are questions you have to ask based on your community. Okay, so they're really, that was Minnesota law. This helps you understand the picture of the laws that exists in Minnesota and other states too. And just a different way and kind of a universal way that sometimes is easier to understand. So the first is the ability or disparity of force. So the question is, does your assailant have the ability to kill you or cause you great bodily harm? Okay. And the ability might be the weapons they have, the distance they are, things like that. But disparity in force is another part of that. And disparity of force would be things like force in numbers or huge size and strength, a male attacking a female. So for example, we wouldn't expect the average citizen, I believe, and I think studies have proven this, would agree that the use of a firearm to end an attack would, there'd be a lower bar for an 85-year-old woman fighting off a 21-year-old male than it would be for a 40-year-old male fighting off a 21-year-old male. Okay. A disabled person in a wheelchair is going to be more reasonable in using deadly force than against an able-bodied attacker than a healthy, non-disabled person. Your attacker is a highly skilled attacker, somebody who's an accomplished martial artist or maybe a Navy SEAL or something. Now remember, you have to know this at that time that you take that action, not stuff you learn later. And then a position of disadvantage. So an example of that would be, your partner is on the ground and he's being kicked in the head by 3 dudes. You have some defense. You have a better likelihood of justifying your use of deadly force in that example. Okay. The next element is opportunity. So the question here is the aggressor capable of deploying the threat now? So for instance, I have somebody with a knife and they're, they call me on the phone and they say, I'm going to kill you, you SOB. I'm going to come over there and stab you. Well, they don't have the opportunity to do that right now. So ability is the ability to do it. Does he have the ability? Yeah, he's got a weapon. Absolutely. Opportunity, it's not satisfied in that example. Now, if the guy was 15 feet away from me with a knife saying, I'm going to cut you right now, you SOB. Well, now we have ability and we have opportunity. And sometimes distance is a factor with edged weapons and blunt instruments. Obviously, the firearm, the length of how far a round can go. So distance usually doesn't come into play in firearm encounters. But distance comes into play with other types of encounters. And so people are oftentimes heard about the 21-foot rule. This is actually research done by Dennis Tueller. And Dennis is still alive. He actually teaches for the Glock company. And he did research that showed that for the average, this was for police officers, but it's certainly true for private citizens, that the average time it would take to pull a pistol out is less than time than it would take for somebody to start from a stopped position and run at you and reach you. So the 21-foot rule 21 feet became the danger zone. And so we're going to watch a video in a second here, but think of about a car length and a half for 21 feet. That's about the distance of what we're looking at, a car length and a half. So let's watch a video of this in action. If we can get it to start. One second, here we go.
People have been asking to see the Tueller drill in action. We did that in one episode of The Proving Ground, so let's take a look at what happens when Adam charges at our trainee.
What are you gonna do, Mike?
I don't want any trouble.
What are you gonna do?
What are you gonna do? Stay back, just stay back. A lot of people call the Tula drill the 21-foot rule, but it's really not a hard and fast rule. This is just an opportunity for you to understand how quickly somebody can cover ground and get on top of you in a deadly incident. And it also shows how slowly you can get your gun out and put 2 rounds on target to try to stop this threat. That space, typically about 21 feet, sometimes 25 feet or more, gets covered very quickly, especially if you have an active, aggressive attacker. This is something you need to consider if somebody's charging at you. First thing to do is move, get off the X, and then make sure you're getting your gun into play and getting rounds on target. But honestly, this happens very, very quickly. And if you're not prepared for it, you're going to find yourself behind the curve. I'm Kevin Michalowski, editor of Concealed Carry Magazine.
So as you can see, that's 21 feet is about the distance that you can get. Anything short of that, and he's going to have a knife in you or a hammer to your head before you have the opportunity to get that gun out of the holster. So the first one was ability. You know, does the person actually have the ability to say what they're going to say? You know, an 8-year-old kid with a cap gun saying, "I'm going to kill you," or a squirt gun that you know isn't real, is a lot different than, you know, a 15-year-old that has a real pistol pointed at you, or something you believe to be a real pistol pointed at you. So the ability of the attacker to do you harm. The next one is the opportunity for them to do it, meaning they're close enough or they're within range of the weapon's use to harm you. And then the third is jeopardy. So jeopardy is usually about the manifest intent, meaning what are they saying they're going to do? What are their nonverbal skills telling me they're going to do? Or nonverbal behaviors, excuse me, are telling me that they're going to do. And it's basically the intention to inflict the death or great bodily harm, and whether it was made known to you by the words and actions of the attacker. There's a case here called Indiana versus Charles and Tyne that might be worth reading. That kind of goes over that. So remember AOJ, ability, opportunity, and jeopardy. You know, I was in a firearms instructor course this weekend. There were 20 of us plus instructors. So there were about 22, 23, you know, armed people in that classroom. They all had the ability to kill me. They all had the opportunity to kill me, right? So they were armed. They were within the range of the weapon. No doubt about those two. But I wasn't in jeopardy because I had no way to believe that anybody there was going to shoot me. Nobody made a comment they were going to shoot me. Nobody acted in a way that a reasonable person would believe they would shoot me. And so because jeopardy wasn't there, there would be no legal justification for me to do anything. The final one is preclusion. So AOJ is about the attacker. Does the attacker have the ability? Does the attacker have an opportunity? Does the attacker put me in jeopardy because of their manifest intent? Preclusion is about you. And this is the final element here. Preclusion is about you, and it's about whether you acted reasonably as another reasonable, prudent person. Remember the reasonable man standard. Would you act like those jurors would act in a similar circumstance? So an example of that would be, could you have gotten away? Could you have used verbal de-escalation skills? Could you have used a different tool? Could you have retreated? So preclusion is about your actions to get out of that situation. So in order to be successful in a self-defense claim under case law, you have to prove the ability, the attacker had the ability, the opportunity, and made their intent known to you, and that you didn't have any other option. So A, O, J, P, ability, opportunity, jeopardy, and preclusion. And that might be on your written exam, so keep that in mind. So let's listen to Masada Ayub. He's a world famous use of force instructor, trainer, and expert witness. He's testified in many cases. I had the opportunity to spend 5 days and about 44 hours in his classroom learning from him about the use of force law throughout the country. Like I said, he's testified in federal and state trials for 35 years. and is widely considered one of America's foremost experts in defending police officers, civilians, professional security, and private detectives in use of force encounters as an expert witness.
Hey gang, Masada Ayub here for Wilson Combat, reminding you to subscribe to the Wilson Combat channel and be sure to press that little notification bell to keep you alert to some of the other brain food that hopefully is coming down the pike. I've been asked to talk to you today about when it's justifiable for the private citizen to use lethal force in self-defense. The great Colonel Jeff Cooper said famously, owning a Stradivarius doesn't make you a violinist, and owning the finest of defensive pistols doesn't make you a gunfighter. You need to know how, but every bit as important, if not more so, you need to know when. So what does justify the use of deadly force by a private citizen? First, let's quantify the term. Deadly force or lethal force, the terms are interchangeable, is that degree of force that a reasonable, prudent person would consider capable or likely to cause death or great bodily harm. The states will define great bodily harm differently, but generally it means crippling or disfiguring injury. Well, consider you have had to shoot someone in self-defense. Your defense, which is going to be a plea of self-defense, picture it resting on a table that's supported by 3 legs. The top of that table is the set of circumstances, the situation that justifies deadly force. That's a situation of immediate, otherwise unavoidable danger of death or great bodily harm to yourself or some other innocent person that you have a right to protect. That situation, that set of circumstances, that table, stands on 3 legs that are the criteria which create the situation. Different schools have used different terms, but the oldest and most commonly used set of terms is ability, opportunity, and jeopardy. Ability means the opponent has the power to kill or to cripple. It's most obvious when he's armed with a per se weapon. He has a gun, he has a knife, he has a club. It can also be a situation of what the law calls disparity of force. Disparity of force means your opponent is ostensibly unarmed. He doesn't have a weapon per se, but his physical advantage over you in the course of a violent assault is so great that with bare hands and bare feet, he can cause death or great bodily harm. And that, in essence, that physical advantage is so great it becomes the equivalent of a deadly weapon. And a law warrants your recourse to a per se deadly weapon like one of these. Disparity of force can take any of the number of forms. Force of numbers, 2 or more attackers, and you're alone in defense. Significant disparity of size or strength that favors the opponent over you. The opponent is known or obviously recognizable to have extremely high skill in unarmed combat. Perhaps you know he used to be a professional boxer, a black belt, the old saying of the black belt registering his hands. Or you've seen him sidekick a 6'2" security guard through a plate glass window. Close enough, you realize this is a physical force that you can't compete with bare hands. It could also be an able-bodied person attacking a handicapped person, even if the handicap has taken place in the course of the instant assault. It can also be a position of disadvantage. That is, let's say you and the opponent are equal in size to strength, but perhaps he's even smaller than you. But he has you in a position where he's banging your head against a brick wall, and you know if this continues, you're going to die or be profoundly brain damaged, and there's no other way to stop it. Another common element is generally male attacking female. The law generally recognizes that the male has greater size, greater upper body strength than the female of our species, and is also more culturally predicated toward physical violence. The opportunity factor means he's capable of immediately employing that power to kill or cripple. let's say he's armed with a deadly weapon, and let's say he's got a knife or a club. Let's say he's about a football field away from you, and he's yelling, "I'm going to slash your throat." Well, he's threatening death. He has the power to kill, but at that distance, he cannot employ it. If at the same distance, he has an AK-47 rifle, and he's yelling, "I'll kill you," well, now he has ability and opportunity and jeopardy, and now he is an immediate deadly threat. Generally, the opportunity element will comprise distance and or obstacles between him and you. The third element is jeopardy. Jeopardy means manifest intent. That's intent manifested by words and or actions to cause death or great bodily harm. Maybe he's never uttered a word, but he's coming at you with his lips drawn back in a snarl. His eyes are narrowed on you with a target focus, and he has an upraised knife. This is probably not an itinerant cutlery salesman come to show you his wares. He can reach you very quickly. As to the classic example of the opportunity factor is Dennis Tooler's research going back to 1983 that showed the average adult male from a standing start could close 7 yards, 21 feet, and inflict a fatal knife wound in an average time of a second and a half. And we've seen people close that gap and strike in a little under a second. So the manifest intent element is, in an armed society, often the most fungible. I'm sitting here in a studio. There are at least 4 of us in the room. At least half of us, if not more, are carrying lethal weapons. We're all armed. We're all close enough to kill each other with knife or a gun. And none of us are shooting the others because none of us is manifesting to the others an intent to kill or cripple. So with weapons present, the jeopardy factor will generally be the deciding element. Let me give you an example of the ability, opportunity, jeopardy triad being applied. And a case probably all of you are familiar with to some degree. State of Florida versus George Zimmerman in the death of Trayvon Martin. The shooting occurred in late February of 2012 in Sanford, Florida. And the acquittal took place after, I think, 7 weeks of trial on July 13, 2013. The public had been told innocent child skipping down the street with a box of Skittles, gunned down to satisfy the bloodlust of a racist. To understand why the self-defense claim was totally accepted by the jury, we have to analyze those 3 points: ability, opportunity, and jeopardy. The ability, the power to kill element, was really twofold. The evidence was clear that Zimmerman was down on his back and his head was being pounded on the concrete by the taller young man above him. That's deadly force in and of itself. As Don West, the co-counsel, said in his summation for the defense, the sidewalk had become the weapon. And really, it's not going to matter if I pick up a chunk of concrete and smash you in the base of the skull with it, or I smash the base of your skull into the concrete. The damage is going to be much the same. What was also going on in that element, Zimmerman testified, well, he didn't testify at the trial, but he stated to the police, and that statement did go into the jury, that in the instant before he drew the gun and fired, the young man on top of him had observed the gun and the inside the waistband holster on his hip and said, "You're going to die tonight," and had reached for the gun. And Zimmerman testified he batted the hand away, drew, and fired the single shot that ended the encounter fatally. That was 2 elements of ability right there. Opportunity, the capability of employing it, they were in direct physical contact. The evidence was consistent with Zimmerman's account that he was down on his back with young Martin on top of him, head and hands, pounding his head into the pavement, and essentially a mixed martial arts mount. Otherwise inescapable. Finally, the elements of manifest intent. When you've been punched in the face and the evidence showed that he had been, and knocked down on your back and someone's pounding your head into the pavement, that physical action is basically homicidal. The statement that you're going to die tonight as the man reaches for a gun, whether or not it's your gun that he's reaching for, is another manifest intent to kill element. So all three of those came together. And I thought Mark O'Mara and Don West did a very good job of explaining to the jury that this was a situation of immediate, otherwise unavoidable danger of death or great bodily harm. Now, there's another element that has to be considered, in my opinion, separately called preclusion. And the reason I say considered separately, ability, opportunity, and jeopardy speak to your opponent, what he or she is capable of doing to you. Preclusion speaks to you. Did you start the fight? If so, you were the initial aggressor, and self-defense is no longer going to be a competent defense for you in court. Some states require a retreat, or at least some attempt to retreat, before using deadly force in self-defense. No state requires that when you're attacked by an intruder in your home. Castle doctrine, going back to the common law principle that one's home is one's castle, an attack there, they need not retreat. But even there, things can be fungible. In a domestic dispute, where both people live in the same home, they share castle doctrine, and the attackers essentially cancels out the defenders. And now we're back to straight up self-defense with no legal advantage on either side. Now the determination will be who was the aggressor, who was the innocent victim with the right to fight back using deadly force if it was a deadly force attack. Continuing with the Zimmerman case, we spoke of the element of preclusion. What could you, the defendant, have done to avoid the situation or to mitigate? The accuser said that Zimmerman had started it, that he was the initial aggressor, that he had hunted the guy down. The narrative went that he was a self-appointed community watch. The record showed, and the facts showed at trial, that he was in fact the elected captain of the area's community watch. The Sanford Police Department testified as such. And his job had been to be, as in any neighborhood watch group, to be the eyes and ears of the police, and if they spotted something, to call them. On this particular night, he was not on community watch patrol. He was going out to the grocery store to do an errand. And on this dark, rainy night, he sees this young man pausing, looking into windows, which in an area where there have been burglaries and home invasions was particularly suspicious. So he called it in. The phone call is a matter of record. You can listen to it on YouTube. At one point, the dispatcher says, you've lost sight of him, where did he go? Now, pause briefly, human nature. We're videoing now in the Wilson Combat Studio. If somebody behind that camera asked me, Mass, where did Bill Wilson go? My reaction would be, I don't know, I'll go find him for you. And essentially, that was Zimmerman's reaction. Now, remember, he's supposed to be the eyes and ears of the police department. The dispatcher who asked that question is the voice of the police department. That's at that point, you hear the ding-dang of his car door opening, and you hear the wind in the microphone. The dispatcher asks, are you following him? And he said, yes. And he said, you don't need to do that. And the wind in the microphone stops because he stopped moving forward. And that was when he turned around, broke off the conversation, went back to the car to wait for the police. And it was shortly after he had hung up his cell phone that he was attacked by Trayvon Martin. So basically, the preclusion element showed that he had done nothing wrong and he was not, in fact, the instigator. But all of those things will have to be addressed in a successful defense, as they were successfully addressed in the Zimmerman case. So essentially, you want to make sure you've maintained what the courts call mantle of innocence. You didn't start the fight. You didn't go looking for the fight. You didn't keep the ball rolling when someone else started the fight. Bear in mind, when you're carrying a gun, you bear what the courts call a higher standard of care. You were the one who knew a deadly weapon was present, and a physical altercation, fisticuffs, could at any moment turn into a killing situation. Responsibility comes with the power. They have to be kept in an equal balance. Those are the basic rules. Insofar as retreat requirement, some states, as I said, require it, some do not, some have required it in the past and rescinded it, the so-called stand your ground laws. At the same time, the states that do require retreat do not despair, because all the states that have had that law, if you actually read the fine print and look at the case law, the case law is the determinations of the higher courts, the courts of appeal, to guide the lower courts, the trial courts, and how the basic principles of the law need to be applied. If you look at all the states, retreat has never been demanded unless it can be accomplished in complete safety to oneself and other innocent parties. It's hard for me to picture a situation where if I could have simply walked away, I wouldn't have, and would have wound up using a gun on someone. So basically, those are the primary standards. It must be a situation of immediate, otherwise unavoidable danger of death or great bodily harm to yourself or another innocent party. Those three criteria need to be present. It's not 2 out of 3 isn't bad. You need all three. Ability, the opponent possesses the power to kill. Opportunity, he's capable of immediately employing that power against you or the person you're protecting. And finally, jeopardy, the manifest intent element. He is manifesting an intent by words and or actions to kill or to cripple. Essentially, think of it as a 3-point triangle. Ability, opportunity, jeopardy. And the three of them close together, they're sort of shaped like a spearhead. When that spearhead points at you, at that moment, and really only at that moment, deadly force is justified under American law and standards. I'd like to thank you for watching and remind you to subscribe and stay tuned to the Wilson channel.
Okay. So as I stated, that is Asad Ayub, and really a well-recognized use of force expert. And if you ever have a chance, his course, he has a couple of them, but the kind of flagship course is called MAG 40. It stands for Masad Ayub Group. And 40 stands for the number of hours. So, and it ends up being more from personal experience. So you'll spend, he calls it a major in when and a minor in how. So there's a little bit of shooting. It's not hard. Some basic shooting skills, but you know, about 60 to 70% of the time you're in the classroom learning use of force law. And it's a pricey course. I think it was $1,000, $1,100 plus travel, but definitely worth it. So MAG 40, if you look that up, it's MAG 40, and it's definitely worth your time, money, and effort. So we talked about Minnesota law with use of force. We talked about AOJ, and the P is preclusion, which is unique to states that aren't stand your ground states. And Masad summed it up really well in that video. Let's talk just quickly about alternative options. We already spoke a little bit about these, but retreating, OC spray, taser, hands-on. So if you can avoid having to pull that pistol out and use it, you should. You're the one who brought the pistol to the gunfight, or the gun to the fist fight. And so, you know, you're going to be held to the higher standard, like Mass said. So make sure that you think about what you're carrying. I don't like when people say, if you carry a gun, you shouldn't carry any other, you know, weapons like an OC spray. I carry OC spray every day. I use the palm pepper spray. It has a little clip like a pocket knife, so it sits in my pocket. Nobody can see it. Works very well, and it's extremely unlikely to cause any serious or permanent damage. There is a chance, you know, somebody has asthma or something like that, you could be in a real pickle there. But everybody agrees that that's not, you know, that OC spray is not a deadly weapon. So think about your alternatives, including verbal de-escalation and some of these other options. Okay, so recap on deadly force. In summary, in order to be justified, the use of deadly force must be used in a situation where there is an immediate and unavoidable danger of death or great bodily harm to the innocent. And by innocent, I mean you didn't start the fight, you didn't continue the fight. And the innocent doesn't mean just you. It could mean your children. It could mean your protectee. It could mean if you're an armed guard in a mall, it could be the shoppers. There's different, it's not just you. So let's talk about the duty to retreat. So the duty to retreat is an obligation of a citizen to avoid the necessity of using deadly force, and stand your ground laws modify that. Minnesota and Wisconsin are not stand your ground jurisdictions, so it doesn't apply here. So if you hear about stand your ground, it doesn't work here, at least currently. This video is being made in June of 2022, by the way. So duty to retreat certainly includes running away, hiding, etc. And generally, you must attempt a duty to retreat or be prepared to explain why a reasonable person, not you, but a reasonably prudent person, couldn't. And again, remember, there's nuance. If you're an armed security guard in a school or a mall and there's an active shooter, that's different than if you're the citizen and you find yourself, in a parking lot, right? You have a different duty when you're performing a function like that. So when should you not retreat? I think that's the question. So you should not retreat when you'd place yourself in more danger by running away or hiding or retreating than you would if you engaged. Remember, Mossad said, even the states that don't have stand your ground don't require you to retreat if it puts you in danger. So we don't turn our back on an armed attacker with a gun or knife that's in striking distance, right? But we might turn our back and run away from somebody with a knife that's 50 feet away. That probably would be appropriate. It's also not appropriate when you would leave another person to whom you owe a duty in danger of death or great bodily harm. So nobody expects you to run away from the knife-wielding attacker and leave your 5-year-old child behind. Nobody expects you to, if you're an armed security officer or an executive protection specialist, to run away and leave your client standing 2 feet from the guy who's trying to stab him. That's not what we're talking about here. So it's important to understand that. So CYA doesn't mean cover your ass. That's not what it stands for in our context. It means, can you articulate? Can you give a convincing explanation that a reasonable, prudent person would believe? Can you show the jury why you did what you did? Can you show them that you were taught to do it in training like this one and others? Can you show them that it was the right thing to do? Let's use the 21-foot Tooler drill as an example. If you shoot somebody who is 15 feet away from you with a knife, you need to be able to explain the reason is because I know from my training that person was in well enough close distance to get to me before I was able to get to them. If you can't explain that and you don't have a basis for it, like your training, the video you watched, then it's a problem. You don't have to be right, but you do have to be reasonable. Excuse me. An example of that would be the shooting that occurred in Ohio a few years ago. I forget the name of the party involved, but it was a young boy. Sadly, he was about 12 years old, and he had a BB gun or an airsoft gun with the orange tip torn off. The police had gotten a call that there was a man in the park with a gun. This particular 12-year-old did not look 12. He looked like a late teenage boy. He was a good-sized kid. The officer arrived, the two officers, and as they pulled in, there is a kid pointing this gun at them. They did not know that it was not a real gun, and they engaged him and killed him, this little boy. The officers weren't right. They were wrong. It was a fake gun. But it was reasonable and deemed to be reasonable because they had no way of knowing that. They had a legitimate duty to respond to that call. They, at that time, believed he had the ability. He was armed with a deadly weapon. He had the opportunity. He was within striking distance. He wasn't far from the car. And number three, he was pointing it at him, which satisfies the jeopardy issue. And preclusion doesn't apply necessarily to law enforcement. So they were justified in that shooting. Now, that doesn't take away the fact that a young boy needlessly died. And it's a very sad situation that I'm sure the policeman involved, and certainly the young boy's family, carries with them for the rest of their lives. And none of us, I'm sure, I know I don't ever want to be in a situation where I have to use deadly force, let alone in a situation like that. But at the same time, it was reasonable. So it wasn't right. Wasn't correct, I should say. Right gives a moral implication, but it wasn't correct, but it was reasonable. So things to avoid. Let's talk about what you should avoid. These are things that I see all the time. Avoid things that would be deemed indicia of malice. Examples are clothing or bumper stickers with slogans that say stupid things like protected by Smith and Wesson, or you know, you'll see sometimes signs on houses. Our investigators serve a lot of papers, so we go to a lot of people's homes and we'll see stickers on the front door that say, you know, stupid things, protected by the NRA and things like that. Avoid custom firearms parts with words etched in. There's a great case out of Arizona. And what the case was officers responded to a report of a man with a long gun at a hotel or an apartment building. I don't remember it, but that's not really applicable to the story. The police responded with long guns. And as it turned out, the gentleman was using a high-powered air gun as part of his job. I think he was killing rodents or something on a pipeline. And he was pointing it at people, and he was a little out of control. I don't know if he was under the influence or had some mental health issues. And the officer responded and killed him with his long gun. And the prosecutor charged the police officer with the crime. And one of the key aspects of that crime was this particular department. I think it was Phoenix, but I might be wrong about that. It was something in Arizona. This particular department allowed officers to have their own long guns. The city, I don't remember if the city didn't provide them or just gave the option to the officer to bring their own long gun. But this particular officer had his own rifle, consistent with department policy that he used on duty. And he had etched in there, laser etched, "You're fucked." And that was used against him in the trial. It was used against him pretty successfully in the trial. And there's just no reason to have guns or equipment that, again, go back to our earlier discussion about looking and acting professionally. That doesn't look good to a jury. It looks like you're excited about this, that you want to, you can't wait to engage in some sort of a firefight, and it's just not a good idea. So don't have stupid bumper stickers, clothing, things like that. Don't have ridiculous things laser etched into your firearm. Tactical Timmy gear. Tactical Timmy, that's the guy at the range that comes in with 5'11" pants and a Glock hat and all this crap on him. And it makes you look like you are on a mission, that you are prepared for this. You're excited about this. And it gives the jury a wrong impression. So avoid that. Avoid social media posts that, are inflammatory. One of the things I did after taking Mag 40s, I took down a lot of my social media posts where I liked different types of posts about gun rights and posts about incidents that have occurred. And the reason is twofold. Number one, it gives the impression falsely that I think it's good for people to shoot other people. I don't. And I don't want people believing that. And it doesn't send the right message, and it doesn't send the message that's in my heart and mind. And it could be used against me, even though I don't necessarily feel the way that those posts would imply. Watch out, when you shoot somebody, the police are going to, depending on the circumstance, they're probably going to get a warrant for your home, and they're going to go through your stuff. And so think about the books that you have, or the media that you have. If you have things like the Turner Diaries, which is a book written about anarchy, if you have books or materials that make you look like you're Tim McVeigh or that you're fascinated by this, don't have them. Don't have them. One of the things we'll ask people to do is if you have them because you're researching these things, then have a tag on your bookshelf that says research material. Make it clear that you're not reading this for fun, you're reading this for education or for scholarship. Avoid modifying triggers and other gun parts, that anything that makes the gun easier to fire. So don't remove manual safeties from the firearm. Don't send it to the gunsmith to put in a lighter trigger. I see that a lot with Glocks. You know, everybody says Glock perfection, Glock, 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 Glock. And it's the only gun I know that's perfect, but still needs to be completely redone when you buy it. Needs new sights, needs a new trigger, needs a, you know, now they have those safety things on the back of the slide that allow you to safely holster it. Which is why I don't like Glocks, but it looks like you're creating a trigger finger. So one of the things we'll do is we have a policy in our company that the gun you use at work cannot be modified. It has to be stock. If you're going to change a trigger, you can, if one, the manufacturer does it. So not some gunsmith at the local range, but you've sent it to Glock, you've sent it to SIG, you've sent it to Walther. Number two is that it doesn't change the pull weight on the trigger. So if it's a 5.5 pound trigger that Glock puts on their Glock 19, and you're going to send it to Glock to have a different trigger put on, it needs to be a 5.5 pound trigger when you get it back. And we don't want to modify our pistols to make them easier to go off. It's not necessarily safe, and can be less, but it can be unsafe. And B, it gives the impression, whether it's true or not, it gives the impression that you are a little bit trigger happy, and we don't want to do that. The case that I was referencing earlier about the rifle of the police officer is actually Arizona versus Brailsford, and you should look that up and read that case. The other thing to avoid is ammunition. That's ridiculous. So our ammunition selection for carry should be jacketed hollow points by a premium manufacturer. That would be your Federal, Spear, Sig Sauer, things like that. Don't get these novelty bullets because they will be used against you. So we've seen zombie bullets and tracer bullets and streak bullets, and those are fine for the range, but for your carry gun, it's got to be one of the big main manufacturers of jacketed hollow points, and the, you know, no armor piercing bullets and things like that, even if they're legal. Just because they're legal doesn't mean it won't be used against you. The reason is kind of the pet reflects the personality of its owner. We've all seen that, you know, different people take pictures of their animals and they kind of look alike sometimes. You know, when the average Joe citizen shows up for jury duty, when that grandmother who's 65, the retired school teacher, shows up for jury duty, they're probably not going to be impressed by zombie bullets. They're probably not going to be impressed by "you're fucked" etched into your gun. It makes you look out of control, and it makes you look like you're bloodthirsty. And we already talked about modifications that remove or alter safety features. We don't want to do that. Okay, we're going to move into stages of intervention. So what happens when you have to use deadly force? Well, the first stage is prevention. Let's not do that if we don't have to do that. If we can get everybody out of the mall without anybody getting killed while the madman is running around, let's do that. You know, if we can get our family out of the parking garage without being attacked by somebody, let's do that. Intervention is the use of deadly force, and postvention is what we do afterwards. So the stages of intervention and postvention are interactions with the suspect, the witnesses, responding law enforcement investigators. So what do we do with the suspect? So we've shot the suspect, and we need to remember to stay in condition red, not condition black. And we're certainly at red here. We're also realizing where there's one, there's two, where there's two, there's three, so on and so forth. So we want to make commands loud, clear, and calm because we want the suspect to hear it. We want everybody else to hear what we're going to say. So things like don't move, drop the weapon, don't touch the weapon. When you can, preface things with slowly drop the weapon, things like that. You know, if they're still functional, have them lie face down with their palms up until the police arrive, someplace that you can be sure that they're no longer a harm to you. With the witnesses, the goal is to let them know that they don't need to fear you, that we want to keep them safe from this attacker as well. See if they need anything. Has anybody been harmed? You know, look around. Has he hurt anybody else? What we're doing is we're giving the impression, the true impression to the other people in the room that I'm the professional here. I'm a good person. I'm acting correctly. If I'm not in a uniform, it gives the impression that you're not just the average citizen. So say that, don't move, lay down, whatever you're going to tell the suspect. Has he hurt anybody else? Look around. Has he hurt anybody else? That's for two reasons. Number one, we want to make sure there's not anybody who has been shot or harmed anywhere else in that area. We want to make sure none of our bullets went past our guy and into some innocent person. We need a head count of how many injured parties there are. Okay. When the officers arrive, one of the things we want to do is assign a welcome wagon. So realize that if you have a shooting and you've told the witnesses, look around, has he hurt anybody else? No, okay, you call 911. You're going to have a lot of responding police, and we don't know which officers are going to respond. Some of them might be experienced, seasoned officers. Some of them might be on their first day. Some of them might be very nervous about a gun call. Some of them might be very calm about a gun call. Some of them might be in condition red. Some of them might be in condition black. And so we want to avoid the police walking into that scene, seeing you, especially if you don't have a uniform on, with a pistol, and mistaking you for somebody that they need to deal with. So what I say is either call 911 yourself right away or instruct a witness to do so. Make sure everyone hears you tell that witness to call 911. Give the location of the incident, repeat it. Assign somebody to wait for the police at the door so that when they get there, that the person at the door can guide the police to the location, let them know where it's at, let them know that you are not a danger. And as soon as you hear those sirens or see those blue lights or red lights, holster your weapon. Holster your weapon. If you need to keep your hand on the butt until the police, until you see the actual policeman, that's fine. The reason you're doing that is in case this guy comes back up. But as soon as you know the police are there, get your hand off that gun and get your hands up. Let them know that you are not a threat to them. We don't want you to be shot. And there's going to be an example of that. And then realize the roles that are being played and how the stage is set. Think about you coming into that scene and not knowing what happened, not knowing there was a robbery, not knowing that, the guy in the blue shirt is a private detective or a protective agent on a security detail. The policemen aren't going to know that. And we don't want you to get shot. Okay. So let's talk about what happens when law enforcement arrives.
Hi, I'm Kevin Michalowski, editor of Concealed Carry Magazine. I'm here today with Tom Grieve, a former state prosecutor here in the state of Wisconsin and now criminal defense attorney. We're going to talk to you a little bit about what happens after you're involved in a deadly force incident. If you've had to use your firearm to defend yourself, and let's say you've shot somebody, we'll go from there. The first thing that you can expect to happen is that the police are going to arrive. Obviously, we want you to win that race to 911. We want you to be the complainant. Call the police. And then we always say from a tactical perspective, I want you to move to a position of tactical advantage. You shouldn't really leave the scene unless it's more dangerous to stay there. But get yourself to a position of tactical advantage, find some cover, get your back up against something, and understand that bad guys typically run in pairs. When the shooting starts, the bad guys will probably flee, but maybe they want to come back around. So the police are on their way. And when police officers, sheriff's deputies, or anyone else gets a gun call, a shots fired, 1032, man with a gun, They're going to come in force. They're going to come quickly, and tensions are going to be elevated. There's no other way around that. So be prepared for that as a legally armed citizen. Police are going to arrive on the scene. I would prefer that you keep your gun out and ready to defend yourself until you see red and blue lights arriving and you hear the sirens or the footsteps of the police or something like that, and then immediately get your gun to the ground. If you still have your gun in your hand when the cops show up, you might get shot immediately. You will most certainly get screamed at, and people will be barking commands that will want you to drop the gun. Follow those commands immediately. Don't try to explain anything. Don't try to say anything. Don't do anything except what the police tell you at that time. The reason for that is cops are coming in and they're trained. We always get the same training. Take control of the scene. So if it works perfectly, if it works according to the training we got at the academy, police officers will arrive at a gun call with one officer will arrive first, and immediately he will take over the scene, and that will be the contact officer. He's supposed to be the guy giving all the commands, telling you what to do. Other officers arriving on the scene, if they don't get there at exactly the same time, the other arriving officers as backup are the cover officers. They're supposed to follow the commands of the contact officer, and they're going to be doing things like putting people in handcuffs, separating witnesses, stuff like that. Realize this is in the best case scenario. Everyone is afraid when they're at a gun call. So other cops might be barking commands. Things might take a little while to settle down to get into that contact officer, cover officer situation where we have one person taking control and other people doing things. But expect this. Expect that you will be pulled aside, probably handcuffed. You may be ordered to the ground, face down, hands out like an airplane. You'll be hearing all sorts of commands. Follow them. They'll put the handcuffs on you. They'll move you to a different location because they don't want you to talk to anybody. You're going to lose your gun to evidence. Someone's going to pick up your gun and take it, and that's going to be gone for a while. Tom will address how to get that back a little bit later, but we're going through this sequentially. So they're going to pick up that gun. They want all deadly implements accounted for. If there's somebody laying dead on the ground, stuff might lay there, and we'll mark it with an evidence card, and we'll take pictures of it and stuff like that. But count on your gun being gone. That's just something that's going to happen. At the scene, we're going to mark out everything that happened. We're going to do our best to take pictures. Typically, the way it works in smaller agencies is the arriving officer might also be the investigating officer. In bigger agencies, well, we're going to call the detectives. The detectives are going to come in. They're going to mark things. They're going to start canvassing the area, looking for witnesses and stuff like that. At that point, I don't really want you to say anything. Tom, maybe you can jump in here on the scene. I would suggest that people not say a whole lot to police officers at that time, other than, yep, I was the victim of an assault. If the bad guy ran away, he went that way. Here's kind of what he looks like. That's all I really want to say at this point. What would you advise people to say to officers right at the scene?
Right. So point out any evidence as well. If they miss something, keep in mind that if the attack took place in your garage, in your home, in a driveway, something like that, that baseball bat laying on the floor may not look like evidence to the officer, but that might be with the attack weapon. So you're going to need to make sure that that gets preserved and processed as part of the scene. Likewise, of course, for knives, screwdrivers, and so forth. Usually, I would think that cops, of course, are going to recognize that the gun on the ground, that's probably part of the case. But oftentimes, of course, it may be a box cutter or something entirely benign or different, at least benign when we're talking about how it may appear to an officer processing for evidence. So identify the evidence as well. Otherwise, frankly, the best thing, the safest thing you can do is shut your mouth. Okay. Now, there's going to be a difference between raising your right to silence versus raising your right to an attorney. The better thing to do is raising your right to an attorney, and here's why. We always hear about Miranda warnings and this and that. Look, you've got a right to silence, you've got a right to this, to that, to the other thing. There's very limited circumstances as to actually when those Miranda warnings can come into place. So don't try to be your armchair commander attorney, all right? Because I assure you that the test for when Miranda actually comes into play and those statements actually have to be Mirandized, you have to be given your Miranda warnings, can actually be surprisingly limited. You can actually be handcuffed in the back of a squad car, and they do not need to be giving you Miranda warnings. Law enforcement officers may not need to be giving you Miranda warnings in order for those statements to be admissible and to come in. So don't wait for some sort of, well, I gave them statements, but they didn't give me the Miranda warning, so I'm okay. Leave those determinations to an experienced and qualified criminal defense attorney. not to your episodes of Perry Mason or whatever it is that you had been watching, all right? That's setting yourself up for disaster. Likely you are probably tired, you're fatigued. This may have happened early in the morning. You may have had a long day at work or something else that's going on. You are not going to be in the proper state of mind to go through and rationally, logically, and linearly describe what just took place. I've worked with any number of folks over the years who have been in these sorts of circumstances, and I'm talking to them oftentimes the very next day, the very next morning, and they typically never get any sleep. They've been through an emotional roller coaster, to say the least, and they tell me what happened, and it may not make a lot of sense at first. It's kind of like the analogy I like to use is, you know how when you are cleaning up your Christmas decorations or your holiday decorations, and you kind of just throw all the lights in one box, and then next year you open up the box and you're just staring down to that tangled mess. That's kind of what this is. When I'm approaching this as a criminal defense attorney, I'm talking to a client who's just been involved in some sort of situation like this of, all the facts and information is in here, but it's so jumbled, it's so nonlinear. People are jumping around. They're often getting their facts wrong. I've had very credible people just entirely screw up which street they were on at the time when they were attacked. And thank goodness we had actually videotape evidence to corroborate the fact that some sort of gangbanger jumped up behind them and attacked them at the time. But it goes to the point of somebody who is a very successful, no criminal record, middle-aged, and all of a sudden he's utterly disoriented as to what street he's on, let alone some of the other facts that may have happened. If you ever get bored and need that nighttime pleasure reading, go ahead and just look up and Google some of the aspects out there as far as how traumatic experiences can affect how your memory functions. And this is, of course, often layered on top of fatigue, on top of adrenaline rushes, on top of everything else, tunnel vision and so forth, that we know that actually comes into an event like this. So one of the big things that I try to do on the back end, not to jump ahead here, but it's to untangle that string of Christmas lights, to make sure that the story comes out logically, linearly, to make sure that everything gets highlighted and brought to the front. Oftentimes, a very emotional person may give a very emotional rendition about what happened, but they may omit some important facts. Other times, maybe that engineer or somebody who may be a little bit more fact-focused but less emotional may be explaining what happened, but they may not be explaining exactly why they did something. Well, this happened, and this happened. Well, right, so why did those things happen? Well, I had to pull the trigger because I was afraid that they were going to kill me. Great. But guess what he did not include in that initial police interview? He just explained what happened, not what he was thinking when he made that call to draw, to fire, to whatever it is that took place. Now, the reason why I'm flooding this in here is because if you go ahead and if you try to get everything out there, I can reasonably guarantee you that you are going to miss very important things, that it is going to look very sketchy and not very credible to be trying to add or amend that later. There will likely come a time and place to give that interview if you and your attorney choose that it's in your best interests. But take the time to cool down, write it down, talk it over with your spouse, your significant other, and especially your attorney. Attorneys shouldn't be out there trying to manipulate and change facts or to get you to make up and lie and change what happened in essence. That's not our job. Our job is to basically make sure that those Christmas lights get untangled, to make sure that nothing gets missed, and make sure that all the evidence that needs to come to light does come to light in order to preserve your best interest in the fight for you. That's why we want you raising your right to an attorney. Raising your right to silence means that law enforcement can continue to badger you, can continue to harass you, can continue to try to play mind games if they want to, and trust me, they will, as far as, well, you need to give us a statement or this is going to happen. When you raise your right to an attorney, that actually signals a very different paradigm shift of they largely have to disengage and leave you alone until you approach them, if that's what you choose to do, which, by the way, it shouldn't be. But that's the significance. You just want to say something effective, look, officer, I really want to cooperate, but I'm going to talk to my lawyer first. Or even just, I want a lawyer, or I'm not going to answer any questions without my attorney present. Polite, respectful, they're doing their job. They're not out there necessarily to try to hurt you, even though them doing their job may inadvertently, though directly, lead to that. So there's no magic language. You just need to make it clear that you want to talk to an attorney before answering any other questions.
Thanks, Tom. And in most cases, when cops are arriving at the scene, they don't know what's going on. They get a very limited dispatch call. They get, caller states that there's been a shooting, there's somebody down, shots are fired, they give us the address and they send us on our way. We're coming in there not taking sides. We're trying to find all of the information. This isn't the ideal world, understand that cops are human too, and we also have some predetermined notions in our head and things like that, but we're still coming in trying to look at this holistically and see what really happened. So we're going to grab up as many people as we can who are still at the scene. Good guys typically stay at the scene. Bad guys typically run away if they can. We understand that, but we still need to do the interviews. And for lack of a better term, to keep the cops on your side, don't start in with, I know my rights. You didn't read me my rights. You have to do this. You have to do that. I can tell you for certain that 99% of the cops know their job better than you know their job. So just like Tom said, calm down, ask for your attorney and wait. And give them the limited information that you can. Bad guy was dressed like this, looked like this, ran that way. Help them to investigate the case, point out the evidence, but certainly don't start making demands, because it's going to be butting heads with what the police officers are trained to do, which is take command of that scene, make sure that everything is safe. And honestly, when we get there and we want to make sure things are safe, it's because we want to go home safely too. We want to make sure nobody else gets hurt, especially us, and then make sure that we can provide help and try to figure out what's been going on. So we're going to grab up the people there and do interviews. Some might be conducted right there at the scene. We might take the shooter down to the police station, to the sheriff's department, someplace like that, to an interview room to do a further interview, and then decide whether or not we need to book that person into jail. Now, when we get to that point, that's pretty much the drop-off point for cops. We're like, okay, the patrol officers brought the people in. We did an immediate interview. We start putting together a report. We hand it off to the investigators, to the detectives, and then it's going to be in the hands of the detectives, the district attorney, and your defense attorney. So at that point, again, say very little. Ask for your attorney, meet with your attorney, discuss what had happened with your attorney, and give only limited information. And remember, tell your police officer, the police officer who you're talking to, I would like to speak to an attorney. At that point, once we hear that, we can't ask any more guilt-seeking questions or anything like that. We are done. We have to wait until your attorney is present, and those are the rules. And don't get upset. This is all going to take a while because we got there not knowing anything that happened, and we're trying to get that information from you and the other witnesses. So now you're sitting at jail, or at the jail in an interrogation room, and you want to get an attorney. Tell us what happens at that point.
Well, for starters, this is not Hollywood, right? What happens in Hollywood? Your defense attorney kicks in the door to the police station, then into the room that you're being interrogated in, and tells the detectives to scram as he's holding, that styrofoam cup of coffee, and he slams his suitcase down on the table. Yeah, if I do that, that's how I go to jail too. All right, that's just not the way it works. Folks, you have to raise your own rights. I cannot fax in a piece of paper saying that you're raising your right to an attorney. Your spouse cannot do that. Your best friend cannot do that. Even if I show up and I'm banging on the door and yelling at, I cannot do that for you unless you're mentally incapacitated, but hopefully that's not the case. Instead, you have to be the one to raise your own rights. So this is the important thing here of, look, attorneys can do a lot of things, but at the end of the day, we can't change time, we cannot change facts, and we cannot put words into your mouth contrary to what it may look like on TV sometimes. Ventriloquism would be an interesting ability to teach in law school, but until they start doing that, you need to stand on your own 2 feet and actually raise your own rights. So they're going to be bringing you to that interview process. Hopefully you immediately raise your right to an attorney. And then at that point, the officers are going to have a decision as to whether or not they're going to be booking you and releasing you, or booking you and putting you in jail. Kevin, what's the thought process on that?
Typically in our jurisdiction is we do a book and release unless there's some reason that, we believe there's a flight or something like that, a flight risk or a problem or a danger. And that's just a policy with our organization, with our department, is that somebody's going into jail, we're booking them to make sure that we know what's going on based on the severity of the crime. If we think that it was a self-defense shooting and the evidence is bearing that out, and the discussion that we're having and the things that we're seeing at the scene is, yes, this person was involved in the self-defense shooting. Yep, that person's probably going to get booked and released, and we're going to say, hey, we need to know where to get a hold of you. hang around, the old don't leave town sort of thing. If we think that that indication might have been a murder or an assault or something like that, and we've got the person who did that, that person's staying in jail until the judge says we got to release him, whether he's going to sign.
You're
a
not
bond
gonna
or
let that
something like
person go?
Yeah, no, that
No,
was-
all right.
So, but typically in our jurisdiction, people are not in jail long until they have been brought through the trial system and found guilty, and then they're assigned to either county jail or prison.
Keep in mind that your local listings, as Kevin would say, may vary. So check them and understand it's going to be virtually impossible to always check them, right? How do you know how your particular police department, sheriff's department, or God forbid, wherever it is that this would take place, how do you know what they're going to be doing, or maybe what they're going to be doing in your particular case, depending upon who's on shift, who gets the call, and various other factors. So it's gonna be impossible to predict that, but understand that there are time limits in your state, wherever you are, as far as how long you are going to be allowed to be held without charges. And then if they do decide to charge you, how long that you are allowed to be held before there either has to be some sort of probable cause hearing, bail determination, or however it works in your particular state. Sometimes this could be basically to try to give you some timelines. We're probably talking about between about maybe 2 to even 5 days is how long this process could play out. Look, nobody's here to defend the process. We are here to educate you and arm you with facts and information so that you don't make the wrong call. Training can make every difference between walking free at the end of the day because you made a good shoot, you made the right decisions as far as understanding how the legal process and how the entire investigation process works its way out, versus not walking free and making some sort of critical error that could have been avoided with proper information and knowledge. And as a result, you're spending the rest of your life behind bars.
So, Tom, if our good guy is sitting in jail and based on either confusing evidence or something like that, we're assuming that our guy did the right thing. But regardless, the investigators have filed a report up to the district attorney and said, it looks like we need to set some charges for this guy. We're going to call the judge and we're going to have a hearing. What's the process then? How long are people going to, we typically do our book and release or have our hearings within 48 hours. So what's the process then? The DA has decided to file charges.
Sure.
What can our guy expect?
So charges have been filed now, and they're going to be setting first. It depends upon the county that you're in. Depends upon if this happened, on a Thursday night, and they've got 4 or 5 days, maybe until your next official court date. They may have to do basically an impromptu court hearing just for bail and probable cause determinations over the weekend or over holiday weekend, believe it or not. That is uncommon in smaller jurisdictions, but it can happen. It's a little bit more common in larger jurisdictions. But more than likely, you are going to have what's going to be called an initial appearance in your case. At the initial appearance, this is not some sort of trial date. There's no impassioned pleas of innocence. It's basically integrating you and your case into the justice system. So this is not an opportunity for you to talk to the prosecutor, the judge, or anything of the sort. Frankly, even if you try to start talking, oftentimes the judge is going to basically tell you to shut down or shut up and sit down. So it's not a high confrontation court date, with the exception of dealing with bail, where sometimes that can turn into a confrontational issue. Maybe the prosecutor is asking for significant cash bail. That could be $100,000, maybe more, maybe less. And that means that, again, depending on how bail works in your state, you may have to have a bank account with $100,000 to post in order for you to get out. Otherwise, you will probably be sitting in jail for the pendency of your case. And if it's a significant felony case, that will often last 8 months, 12 months, 15 months, or longer. We've had at our firm, we're the largest criminal defense firm in the state of Wisconsin, we've had felony cases last 3+ years. Now, those are outliers. The more typical range for a significant felony case to probably be on that 7 to 14 month ballpark. But just understand that this is not going to be over and done with. You can expect court dates probably every 30 to 45 days between one another, as the justice system takes one bite out of your case, then the next, and then the next. And likewise, you and your defense team takes one bite out of your case, and then the next, and the next, as you're receiving information, evidence, digesting that, and assessing the pros and cons, risks, and benefits of option A versus B, B versus C, C versus A, and you just move forward as far as what you want to do, how are you going to be handling this?
Yeah, this is certainly not a 55 minutes and done, on Law and Order or anything like that. I'm following it through. So if you're facing charges and you go for your initial hearing and then decide that they're going to advance this case along, at that point, certainly have an attorney with you. Make sure that you have an attorney. because you are deeply into the legal system. And contrary to what anybody tells you, the only person who is going to be working in your interest is your attorney. Well, Tom, we've talked a lot of great stuff. We've brought people right up to the point where I guess we shouldn't laugh about it. They're at jail, and then we've talked about the bail hearing and stuff like that. The next time we get together, let's take people through what happens, the system. We don't know what happened.
So this video is brought to us by USCCA, the U.S. Concealed Carry Association. They're based in the state of Wisconsin. Some of you might be a member of UCCA. I am. One of the benefits of membership is they provide insurance to pay your legal fees, your bail money, etc. if you're ever involved in a self-defense encounter. One thing to note is the policy specifically excludes security, law enforcement, and private detectives when acting within the scope of your employment. So if you have this insurance, it doesn't apply if you're responding as an armed security guard or an executive protection agent. It would cover you when you're off duty or you're not engaged in that type of work. So it's important to understand that distinction. And I really appreciate Tom Grieve. He's a great attorney. He was a prosecutor, and I hope this helps everybody understand a little bit about the process. So let's get over to this video. We talked earlier about police responding and not knowing who the bad guy is. In this case, a concealed carrier who got involved in a third-party situation that he shouldn't have been involved in, as I recall the story. Hopefully I'm right. Is in the wrong place at the wrong time. And so let's watch this active self-protection video and see what happened here.
The link below. This whole thing starts, we see surveillance footage of a couple of shoplifters who it's not armed robbery, it's shoplifting, and they run off with stuff. And now the guy in the car here, he's the passenger. He tells the driver to go chase those guys down. He's armed, and he decides that he wants to stop them.
By the way, as a private citizen, we should not be chasing people. If you're a security officer, it might be different, but this is a whole lot of bad already starting. So let's watch and see what happens.
So he's going to get them at gunpoint, point a gun at them, but there's an off-duty cop who responds.
He would see the badge cam of the off-duty officer. As he's approaching, he sees, there's someone pointing a gun at someone. He has no idea what the context is and is forced to pull the trigger.
Shoots these guys, shoots him, I think, 5 times. Now, as we slow it down, this guy was an off-duty, was working traffic enforcement in the neighborhood. Sees a guy, issues him multiple commands according to the news stories. When the guy doesn't respond to the multiple commands issued, there's our perp who's, I think, trying to do the right thing and trying to stop these guys. We'll talk about it in the lessons. We'll point a gun at somebody, gets shot. Let's listen to the audio a sec.
No additional suspect. He's down. I guess it's 211. Just pulled the squad here, and caught him in the middle of an additional 211.
You can see the gun right there at his back. So we're going to see one officer secure the firearm, and then these other officers are going to do the very best they can to try to, do some first aid on this guy. Unfortunately, about 5 days later in the hospital, he succumbed to his injuries. We've got significant lessons to learn out of this one as private citizens in crime prevention, as well as not getting shot by the cops. So you probably know that Mike is the host of the Active Self-Protection podcast. And the question everyone's been asking, Mike, when's it going to launch?
It's coming very soon. We have episodes in the can, we have commercials recorded, we have all of it. We just need to get it edited, and we will let you know as soon as it goes live.
Very soon, I promise. Soon-ish. Soon. I think the first lesson here is 100% private citizen related, and that is don't try to insert yourself in places with a firearm that you're not 100% sure that you can do so, because this ended up being aggravated assault.
Absolutely a terrible idea to try to detain someone like that with a firearm. Just follow them, call the cops. Look, I know sometimes these agencies aren't responding to this stuff and it's frustrating, but you see the outcome in this case, it was not worth it.
Right. So again, if you've got somebody that is an armed robber, and right in the middle of the armed robbery, you want to draw your firearm and stop the armed robbery, okay. But detaining a shoplifter with a firearm drawn is aggravated assault. You are committing a crime and putting yourself in the kind of situation where this can happen. Please hear me, to all the private citizens, just don't do it for this reason. Now let's think about the officer's badge cam here. Okay, so he's working off-duty traffic, gets the gun up, and he's issuing commands, but of course the guy doesn't hear him.
auditory exclusion is the most likely culprit here. I just want to press home to everyone, and this is private citizens, off-duty cops, not in uniform. If you draw a weapon in a defensive encounter, or in this case, to detain someone, you have to have your head on a swivel. You have to break that tunnel vision and look around for responding units. This officer wasn't called. He just saw what was going on and stopped. So it can happen a lot faster than you think that the officers arrive. You got to pay attention and make sure you don't end up like this guy.
And listen to commands, right? You've got to listen for the blue to show up, because if you don't, that's exactly what goes down here.
I had an incident years ago when I was a fairly new cop and I was off duty, and I detained some people that were allegedly had a firearm. Turns out he had a fake firearm, but as far as I know, he had a firearm. I had my head in a swivel. When the cops came around the corner, I was holstered with my hands as far away from my waist as I could possibly get them. And I still felt like a little nervous.
And as an officer, you see this guy pointing a gun at people. You don't know what that was. You've issued multiple commands for him to drop it. He doesn't drop it. And so the officer is going to take action to protect those people. That's entirely justified and good. And you see the officer take one shot, second shot, about a quarter-second splits. He's going to run here. You can see the guy is still up as he is shooting. So when the officer finally sees the guy go down, he stopped shooting, and that's the appropriate response. He shot until the threat stopped. Now, if you notice there, he's like, oh, hey, man, that guy in the background was the shoplifter, like, oh, I surrender as well. Man, a bad outcome here. I'm grateful that the officers tried their best to do some first aid here, but honestly, I think this private citizen is the one who's responsible for the outcome.
When I said earlier the officer was forced, he really was forced. How long are you going to wait when you're issuing commands and pointing a gun at someone for them to listen and comply? But he could have pulled the trigger if he had that intent. He could have pulled the trigger before the officer was able to respond. You just have to do what you have to do in the moment. It's unfortunate, but true. I also think this is indicative, one last lesson here, of why somebody can, in a justified manner, get shot in the back. It's not about where you shoot somebody. It's about why you shoot somebody. And because of that, I think these are justifiable actions. It's not a great outcome. It's not the kind of outcome that we want, but
Okay, so the purpose of this video, certainly, you're getting a theme here on third-party encounters for private citizens. But what my purpose of the video is to really talk about realizing that when the police come, they don't know who you are. And you have to be cautious and smart about handling that, so you don't end up being like this guy, who did a lot of bad things leading up to it, but that's not the point of the video. The police did not know that this was a citizen trying to make a citizen's arrest or whatever he was doing, and lost his life for it. Okay, so you've had a shooting. The patrol officers have shown up. They've taken your weapon. They've placed you in the back of the car, brought you to the station or the sheriff's office, and there's going to be a detective that talks to you at some point. You're going to feel a compulsive need to share what happened and tell your side of the story. Don't. It's called logorrhea, diarrhea of the mouth, is basically what it means. You're going to be upset and you're going to want to tell the story, and you have to resist the urge. Like Tom Greaves said earlier, you got to get an attorney and talk to the attorney before you meet with the police. One of the things that I tell my students is, if you've had to shoot somebody, when the police arrive, tell them that person forced me to shoot them. They robbed me, they, and I'm happy to sign a complaint. Now, notice I didn't say, and then I. It was, here's what they did. I'm happy to sign a complaint. I want to sign a complaint against them. And I'm happy to give you a full statement after I talk to my attorney. Only give a statement when it's videotaped. Audio doesn't give the full picture. Hand gestures can't be captured with audio. Trying to show the distances doesn't work with audio. So make sure it's audio and videotaped. Prepare mentally to spend some time in jail. Expect to go to jail. If you expect it before it happens, then you're gonna have less of a feel an urge to try to get yourself out of jail by telling him all the things that you did and he did. And then avoid talking to your friends or spouse about it or anybody else until the legal process is resolved, because your cell phone records, your text messages, your emails, the first thing they're going to take is your phone. And they're going to get a warrant for it because it's not hard to get a warrant. And they're going to know who you talked to. They're going to know what you texted. They're going to know what you emailed, which is, again, why we don't want to put stupid social media posts up even before a shooting. And if they know that you shot somebody, you called the police, and then you called and talked to your best friend, they're going to subpoena your best friend, and he or she's going to be forced to say everything that you said to the investigators. And so you don't want to create additional hurdles for yourself. So just keep your mouth shut. All right. So we're reaching the end of our lesson on the legal implications of the use of force. For Church and Associates employees, we have a use of force policy, and it's a part of our policy manual, and it'll be provided to you. You'll need to read that. Covers a lot of things we have in here, as well as some equipment requirements and things like that. Make sure you read your entire packet. It's a PDF packet. You have to read all of it because there are test questions on different parts of it, as well as the lecture. And when we get together for a range time, we're going to spend a considerable amount of time together in person. We're going to learn a lot of practical skills, including how do we present a firearm from the holster? How do we draw? How do we get our sight picture, our sight alignment taken care of? How do we handle malfunctions in clearing, our grip, our stance? How do we retain our weapon in a struggle? How do we recover our weapon if it's been taken away? Trigger control, we're going to talk about follow through and recovery. And then, of course, we're actually going to shoot and do the qualifications. So it's not going to be a 2-hour meeting on the range. It's going to be a little bit more of an extensive part of a day. So realize that. And with that, folks, that's the conclusion of our lecture on our firearms for private detectives and protective agents. So thank you for participating, and I'll see you on the range.